What is the dark side of free speech? The dark side of free speech is the set of hard cases where words do not merely express ideas, but help create real-world harm, especially when hateful messages target vulnerable groups and violence follows. Free speech is the freedom to express opinions without government punishment. That is the clean definition. The intrigue begins when speech becomes a weapon. Propaganda that dehumanizes, threats that terrorize, lies that mobilize mobs, or online campaigns that incite harassment. In those moments, people ask a searing question. When hate kills and judges seem to do nothing, is the law broken, or is it doing exactly what it was designed to do? A quick origin story helps. In the liberal tradition, free speech is a shield against state power and a tool for truth. Courts historically favored vibrant debate, even caustic and offensive speech, on the theory that bad ideas should be met with better ideas, not handcuffs. Over time, judges drew narrow, carefully policed exceptions: incitement to imminent lawless action, true threats, obscenity, defamation, fraud, and the like. Outside those tight boxes, even repugnant speech is protected. Why so narrow? Because the same government that silences hate today could silence dissent tomorrow. The law therefore gambles that sunlight and counterspeech are safer than censorship. So why does it feel in the hardest cases as if judges do nothing? The answer lies in the demanding elements that must be proven before punishment is allowed. Take incitement. It is not enough that the words are hateful or that violence is a foreseeable byproduct. The law usually requires intent to spark unlawful action, imminence in time, and likelihood that the words will in fact produce that action. Those hurdles are high by design. A demagogue who spews toxic lies may be morally responsible for creating a climate of hate, yet legally untouchable unless the speech crosses that precise line. This gap between moral blame and legal proof fuels the public's fury. Consider true threats. The state can punish statements that a reasonable person would read as a serious expression of intent to harm, directed at an identifiable target. But courts will ask, was it a genuine threat or rhetorical hyperbole, art, satire, or political exaggeration? Did the speaker mean to threaten, or was the fear a byproduct rather than the point? These questions are fact-intensive, and in close cases, judges err on the side of liberty. To victims, that caution can look like indifference. History also shows the danger of broad bans. Vague laws against hateful or extremist speech have often been weaponized against religious minorities, labor organizers, civil rights leaders, and dissidents. That is why modern doctrine prizes precision. Punish conduct, not viewpoint. Punish targeted threats, not mere offensiveness. Punish acts of violence, not the expression of unpopular beliefs. In a courtroom, that precision can feel cold. Outside the courthouse, families grieve and communities ask why obvious hate was not enough. There is a structural twist too. Constitutional free speech rules restrain governments, not private actors. A judge cannot order a newspaper to publish a rebuttal or force a social platform to remove vile posts unless some other law applies. Moderation choices by private companies may shape the speech environment more than court rulings do, but those choices are not usually constitutional questions. When people say judges did nothing, sometimes the real power lay elsewhere. Examples make this concrete. A rally speaker uses vicious language about a minority group, then violence erupts later that night. Unless the state proves the speaker intended to ignite immediate unlawful acts and that the crowd was on the cusp of acting, a prosecution may fail. Or an online influencer circulates a doctored image that leads to doxing and harassment. Without a direct, serious threat attributable to that person, criminal liability can be elusive, even if civil tort claims might succeed. In both scenarios, the harm is undeniable, yet the constitutional line is hard to cross. Does that mean the law is helpless? Number. The system can focus on conduct tightly linked to harm, prosecuting true threats and stalking, enhancing penalties for bias-motivated crimes, enforcing conspiracy and solicitation statutes when coordination and intent are provable, and using civil remedies for defamation or intentional infliction of emotional distress. Governments can invest in counterspeech, protection for targets, and rapid response to doxing and swatting. Schools and civic institutions can teach media literacy and bystander intervention. None of this censors ideas. All of it blunts harm. A curiosity to close. Free speech is often praised as a marketplace where truth eventually wins. Markets, however, need rules against fraud, monopolies, and coercion. Likewise, the speech marketplace requires careful guardrails against targeted threats and coordinated violence. The challenge for judges is to prune the thorns without uprooting the rose. When they appear to do nothing, they are often honoring a hard bargain struck to protect tomorrow's dissent, even as today's hatred tests the limits of our patience and our courage. Above, I leave you more videos so you can keep learning law. Remember to leave us a like and subscribe.